Hello, friends. Welcome to Investment Immigration Conversations. I'm your host, Carolyn Lee, principal and founder of Carolyn Lee PLLC, a U.S. immigration law firm dedicated to helping clients build their futures with investment immigration. Today, I am joined by a very respected figure, well known in the immigration bar for his cross-border tax acumen. Clayton Cartwright. Yay, the crowd goes wild. I first got to know of Clayton when I was on a planning board for an international attorney conference sponsored by the American Immigration Lawyers Association, AILA. And we were brainstorming topics and ideas. And of course, international tax came up. And in talking about whom to invite to be panelists, those in the know were like, Clayton Cartwright, naturally, duh, it's a given. And so that is the stature that Clayton has among us immigration attorneys. I get many questions from investor clients and prospective investor clients about key tax questions essential to their immigration planning, but I can't advise them because my competence is limited to investment immigration. So I am grateful that Clayton is in our midst, particularly because he understands so well this important intersection between immigration planning and tax planning. So I'm looking forward to being illumined with my burning questions answered, and those of us joining live can have your burning questions answered as well. A quick notice, Clayton and I are both attorneys. Clayton is also a certified public accountant. So the information that we're putting out there today is informational only in general, and is certainly not advice and should not be taken as such. Stuff you know. So we're going to jump right into some questions for Clayton. And I'm going to be asking questions really from the perspective of the investor who's thinking about immigrating and the interplay with tax. And so to start, so a client, an investor is abroad and is thinking about immigration and just kind of, these ideas are percolating. At what stage should these investors really start seriously thinking about tax planning and look into getting some professional advice here?
Sure. So, I mean, what, not at birth? They haven't been thinking about it at birth. They haven't been thinking about U.S. taxation at birth. So, I mean, those investors who are thinking about, obtaining a work visa, some type of visa to the United States, maybe acquiring lawful permanent residence, they may already have U.S. tax exposure. I mean, to the extent that they have U.S. source income, and many high net worth individuals abroad outside the United States do. And so it may have, they may already should have been thinking about it. So to the extent that they have investments in the United States, particularly investments in say real estate partnerships or anything like that that weren't tied to immigration, they may already have U.S. exposure and they already should be filing U.S. income tax returns. But I mean, in that event, if there's no U.S. exposure, so the U.S. is sort of sealed off from them and they're just starting to think about it here, pretty much simultaneously. I mean, here at the same time. And you're right, Carolyn, immigration and tax, it's often said they walk hand in hand. A colleague of mine, I can't lay credit to it, but a colleague of mine coined the term taxigration here, like in, similar to criminal law and immigration law, crimmigration here. And so we talk about taxigration. And so really it's at that point when the thought of the visa is triggered, tax advice should be running hand in hand. Now that may seem like a dare I use the pun, a foreign concept to an American advisor, to a US advisor, because typically we have immigration lawyers, we have tax advisors, and they kind of sort of stay off in their own little worlds. By the way, I say this with I have some accounting colleagues here. The immigration lawyers tend to have more fun. And I'm raised here, but right, they tend to have more fun. But abroad, tax and immigration, there are often advisors who work in both, particularly in Asia. Okay, and so I mean, I have some very esteemed colleagues, say in Singapore, in Thailand, India. They're working in both fields. Okay, and so it won't be. It's to the immigration lawyers out there. It's not going to be an odd concept to them to say, okay, we need to bring a tax advisor. As a matter of fact, to the immigration lawyer, danger, Will Robinson, to use that analogy. The prospective client or your new client may think that you're actually giving tax advice. And so because they're used to, in other fields, maybe they're looking at other countries because they're getting both immigration and tax advice from other countries, okay, for the same aspect. So obviously we don't want to scare the daylights out of people, but the expectation is the standard, I think, is coordination. And I will say this, gone are the days. I have some excellent colleagues out there who are great immigration lawyers, but the pitfall I see is I only practice immigration. I say, go off and find a tax advisor. That's not the standard anymore. The standard is coordination. And so that doesn't mean that, hours and hours of meetings. It just means that the immigration advisor and the tax advisor need to loop each other in. So they're working in sync and not at cross purposes. And there's lots of ways where they can work at cross purposes.
So it does sound like it does go both ways. So tax advisors and accountants advising foreign nationals and their tax planning should also be looping in tax or immigration counsel and letting clients know that that needs to happen as well.
Yes, and it's only the beginning. Yeah, because maybe I'm being looped in, and I'm pretty much my primary source of business is referrals, and so immigration lawyer is referring business to me, and then I say, oh, who's your tax advisor in Germany? Who's your tax advisor in Spain? I don't have one. Oh, yeah. Or I don't have one. Right, and then you're looping in another, and so you're sort of building this small team, and it seems like a lot. But it isn't a lot. I mean, it would have been a lot in 1971. Okay, when we wrote letters and communicated, quickly by telecopy.
Yeah. Okay. Well, what's interesting about this, Clayton, is that I speak a lot on CLEs and teaching attorneys, and we always say it's important to define the scope of your competence and to define the scope of your representation. So it's really this, what you're saying isn't inconsistent with that. It's actually very consistent with it, because you do stay siloed, if you will, in your zone of competence, but that doesn't mean you don't work in coordination with other professionals who are advancing your client's case kind of more holistically.
That's exactly right. The only thing I mentioned as a potential pitfall is when you assemble a team, in air quotes, somebody should be running lead. And so you need to make sure that you have somebody who's team leader, lead counsel, lead advisor, somebody is there who's serving as a clearinghouse, because you don't want to, the last thing that you want is the client to have 4 different things. I mean, now the client's going to be looped in, but there has to be somebody there who's going to consolidate the advice.
And do you have a feel for who you think the lead should be? Because from my experience, especially counseling regional centers where we have that team approach, you've got the economist, you've got the corporate counsel, you've got securities counsel, you've got immigration, you have business people. So, and when I started, I used to take the perspective, well, it's got to be me. I've got to be the quarterback here. And I've kind of matured into thinking, well, it really depends on who the client best has that relationship with, and who is comfortable in that role and who can do a good job. And it doesn't always have to be me. So do you have a point of view on that?
Well, actually, my point of view is similar to yours, and it's a matter of emotional intelligence. Who does the client connect with here? And sometimes the initial referral comes to me, and I'm a tax lawyer. And to be clear, I am licensed as a CPA. I've had a CPA license for, will be cough 30 years in January. But my shingle.
When you were 5, you got your CPA license? That's
yeah, right. In my crib, the youngest ever. And so, but I will bring in CPAs, my own team of CPAs that will serve. Sometimes the relationship, the trusting relationship, is closer to the CPAs than they are to me. Not the trust, but the level of just conversation.
Yeah.
And so you just have to let it let it grow organically and let that go. You shouldn't. And so you're right. Attorneys shouldn't let pride get in the way here. And certainly if to the extent you may bring a client to the table here and they may prefer to talk to somebody else, and that's okay. That's okay. Now, what isn't okay is the difference is, and I think it's better by an example. When I was a young lawyer, when I started out practicing in Richmond, gosh, back in the late 90s. And that is, I used to have a client who would always call my secretary and then have the question. So can you take Marjorie, can you take the question down here and just bring it over to Clayton? And it's like, and I told the client, I said, it's going to cost you double in time and for me to sort of figure out what's there. I mean, realistically, I wasn't trying to pill us. It's literally going to cost you double.
Yeah.
Just contact me directly. So you have to make sure it's kind of clear who does what.
Yeah.
And on the team. And so you don't want advisors to, to sort of be outside their core competency. That's why you have teams to begin with.
Yeah. Yeah. So coming back to our investor who's abroad. So what are some of the key factors that play into the ingredients of tax counseling, cross-border tax counseling at that early stage? Is it like, I've always been curious, does it matter if the client is single and high net worth? Does it matter if, he or she has children, spouses? What other things like the level of wealth, does that factor in? And is there like a threshold at which things, start to get much, much more complicated kinds of assets? What are those sort of big items of consideration at those initial stages?
Sure. I think the first one is just, what's the reason behind? Put the tax issues aside. Just put them aside. What's the reason why the client wants to visa? And for me, I have to act sort of like a pseudo psychiatrist, psychologist here, and just get to know my client. I mean, this is not something that's new. I mean, we talk about this in continuing education, CLE, as if it's new, but knowing your client has been credo for centuries. And so knowing your client, knowing what their expectations are in terms of their family expectations, their business expectations, understand that first, and then let the advice follow from that. And so, because if you think, and sometimes clients think this, that if you can give them the legal advice and they'll fit their life into it, it really doesn't work in that top-down way. Life is just sort of develops organically. And I mean, it just happens. And so knowing those expectations, I'll give you a live example from last night. I have a client I was advising on tax residency, and he said, oh, well, I've got 7 days left before I trigger this certain threshold. I won't tell you, it's just too complicated. I said, I plan to be in the US for 4 days. That gives me 3 days, here, and I won't trigger it. And then if I apply for permanent residency this year, I said, don't apply for permanent residency this year. I said, you've got, just go off and live your life for the rest of 2021 here without the fear of this. You don't want this to get in the way. And we're in a COVID environment. You don't want this to get in the way of, he has a relationship in the United States. You don't want to get this to get in the way of that. Just live your life here and do everything you want to, and we'll file in January, period. Here and like that. And that was that. I mean, someone who's tied up in the technical advice would say, well, you can do this, if you keep it like this here. But realistically, do you want to be the one as an advisor to tell somebody that your fiance is, in the ICU with COVID, for example, okay, here, and you can't go? No, you don't. And so, I'm a big fan of buffers here and realizing that happens and knowing those expectations. Yeah. And so that's,
Well, I mean, that is counseling, I think, at its pinnacle, is really working with the client where he or she is. Now, but from the standpoint of, and it's always inspiring to hear that as a practitioner, these words of wisdom. But from a client standpoint, I mean, what are those more technical considerations at the outset? Sure. I mean, again, so if a client is 50 million net worth, does that trigger a different set of, considerations and questions and perhaps even alarm bells for a client with 10 million? Does that kind of stuff matter? Family makeup, get a little technical for me.
Sure, of course. Okay, so from just a level of net worth, actually no. And so what I mean by that is I often say that it's kind of easier for me to advise $100 million client than it is a $10 million client in terms of net worth, because it depends upon, for me, the makeup of the investment portfolio. And so here's a technical term. Inbound client has foreign mutual funds. If they acquire U.S. tax residency, those foreign mutual funds very well will be taxed as what we call passive foreign investment companies, PFICs. Yeah, accountants, tax lawyers love an acronym.
Oh,
okay, and I was in DC for 7 years.
Yeah.
And I was in DC for 7 years in government. Love an acronym. Okay, PFICs. Okay, but that's what the best way to describe that without getting too technical is it's tax hell. It's PFICs or tax hell. And so there's no de minimis threshold.
Mm-hmm.
And so a higher net worth client may have the acumen or may have the tolerance to bear the transactional cost, the accounting transactional costs of reporting them doing what needs to be done.
Yeah.
Then a lower net, so they're able to bear the transactional costs is there. I'm not saying that, I favor $100 million clients over $10 million clients. I'm just saying that there's a lot of these rules have no de minimis thresholds to them. And so it's important to realize that. And I think that's a misconception is that, I'm not worth much. And so I'm not going to encounter any of these transactional costs. No. And I will mention something as well here, and that is something called the Foreign Bank Account Report, the FinCEN Form 114, we call it the FBAR, which is the report that U.S. tax residents, taxpayers, U.S. citizens have to report for bank accounts foreign bank accounts that total over 10 grand over the year. The penalties on those, we've seen news reports of people who are at $250,000 of unreported assets. They've been prosecuted and imprisoned. See, because of willful. So I don't want to. I usually don't want to scare somebody, but that's one that I scare. That's scary to me here. And to bring a little news item into the fold here, I'm wondering about the president's bank account with his son right now, because I think it's overseas. And so I pulled this 2019 return, and it says he's not required to file because there's a little spot that's there. And I'm wondering what's going on here with that here, but that's a story for another day. I digress.
It's a story for another day and another conversation. Okay, well,
can I interject one other thing too? Because I didn't answer, there's a question I didn't answer here, because you asked about marriage.
Yeah.
And so oddly, yes. And so it's the oddest point that I have, one of the oddest points I have in an initial consultation. And that is when I'm talking to an individual client, I say, and I always preface it like, this is going to sound odd coming from your tax lawyer. Are you married? And the reason for that is for inbound planning, someone who's moving to the United States, either permanently or temporarily, but they're going to be picking up tax residency. I have more flexibility due to certain elections in the United States for married taxpayers to sort of toggle the date of tax residency. Married taxpayers who are immigrating to the United States can file what's known as a joint return election, either a permanent one, or a one-year one. The permanent one's called a G election. Here's technical terms. The other one's called an H election. But I have the ability to sort of go retro all the way back to the beginning of the year. And that may be powerful for me in engaging in planning. Whereas with a single taxpayer, I have to ask them, okay, where are you planning to spend New Year's Eve? Because I may be instructing them to actually be physically present in the United States on the first day of the year. Here and before COVID, it was easy as, I'll just plan to spend New Year's Eve in New York.
Right.
And be here. But because if they're not, then they may have to file something called the dual status return that splits the year up, which could be favorable or could not be favorable in terms of the loss of certain tax reliefs.
The spousal flexibility or the flexibilities that may be afforded for a married couple, that's interesting. So, obviously a couple is not perhaps going to get married just for a tax break. But that said, we do get clients, right? And they're kind of on the cusp, but they're engaged, the planning is underway. And so if the timing can be a significant enough advantage, it could be a factor along with, all the other things like, can they get their bridesmaids in from around the world on time and things like that. So, what are we talking about? What's the order of the benefit? And I don't know how we can talk about it if it's probably not in terms of numbers, because that would depend. But I mean, is it significant? Is it something that's
Well, I think it matters more for probably on the lower end of the threshold here, those who are not your $100 million client, but maybe your client is 10 million and below, and that's the ability to file a joint tax return for the year. Okay, and be able to claim the full standard deduction.
Gotcha.
And be able, because if you file what's called a dual status return, you can't file one jointly, and you lose the standard deduction, and so that's a big benefit going forward. But it's interesting because I think these sorts of elections sort of arose from. I have to look at the history of this, but I always wondered they arise from like American GIs abroad, who married and brought spouses home here, so they're able to make these elections. Yeah. And you still see that. I mean, you still see Americans abroad, and then we're talking inbound, but Americans abroad who are getting married and they file these elections because they're able to file a joint return, and the spouse who's coming into the marriage is not bringing any income into the marriage. Because keep in mind, a joint return means both taxpayers are declaring, their income, their worldwide income to the United States, and are taxable thereon. Here. So, yeah.
So I feel like I'm now warmed up and ready to kind of ask you.
Let's go.
Roll out the biggies. Okay. Substantial presence. Yeah. So can you just unpack this for us, please? So we have clients who want to establish residency and a tax presence, and clients who are squeamish about what's the deal here? Why is it so important? What's the rule? How does it affect clients? And how does it affect different clients from different jurisdictions?
I have a moan in my that just comes up and just
let it out. It's okay.
Yeah, whenever I hear like a tax presentation where someone starts this, well, you're a tax resident in the United States if you're physically present 180. They start with that. Okay, that's the rule. Okay, but let's talk about the breakdown of the rule, because there's one rule.
Well, state the rule. State the rule. Don't assume that
there's one rule. I am going to state the rule in layman's terms.
Okay.
There's one rule, but Cartwright splits it into two.
Okay.
The reason why I split it into two is that it operates like two. Okay. And so if someone is physically present in the United States for at least 183 days during a calendar year, they are a tax resident in the United States. And unless there is an income tax treaty that says otherwise, that allows them to get out of that. But statutorily, they're in like Flynn. Okay, they're taxable on their worldwide income. They are taxable on as of the first day of physical presence in the United States. This is why a big mistake I see, and I can say this, and maybe I'm stepping on the shoes of tax services, but they go to a tax service and they file just a standard form 1040, just like all of our American viewers know here. That is not the return to file unless they are physically present on January the 1st. Remember, Happy New Year, right? If they're not, they have to file a dual status return. And I actually have a client who I told at the initial consultation, spend New Year's Eve, just plan on spending New Year's, and he didn't. And he acquired lawful permanent resident status during the year. I knew he would. I said, okay, what's your first day of physical presence? January the 4th. I said, nope. Sorry. I said, we have to file a dual status return. He lost the standard deduction. I mean, it didn't cost him that much money. Maybe in the end of the game, maybe it was cheaper for him just to do that than have the plane trip to the US. But still, it's important to make a note of that. That's a simple one. I call that the simple test. All my publications refer to that as the simple test. There is a complex test, okay, which is a true statutory test. Now, hang on. Hang on, get into your captain's chair, Kirk, Spock, You know, in that spot. Kurt Picard, you see, you're a Star Wars fan. I got some Star
Oh,
Trek
yeah.
stuff to throw back.
Okay.
Getting your, get on the bridge here. It is, if you're physically present in the United States for at least 31 days
Mm-hmm.
in the current year, then you add 1/3 of the prior year days. So for example, you know, we're doing 2020 calculations now, right? So at least 31 days in 2020, plus 1/3 of the days in 2019, plus 1/6 of the days in the second preceding year. So that's, yeah, you know, current plus 1/3 plus 1/6. If that's at least 183, you trip the wire and you're tax resident. The difference is that if you trip it under this, what I call the complex test, because I'm a math nerd at heart, so I know the math and whatever, but when you're speaking, I don't like to speak in math terms. And so I call it complex because you have to work through the numbers and everything else. Some clients, piece of cake, other clients, you have to walk through a few times. But the difference is that if you trip the wire of that complex test, then there is a statutory out called closer connection. Okay, and the closer connection exception states that, oh yes, I tripped the wire under this complex test. However, during the whole year, my closer connection is to Japan, it's Singapore, it's wherever. And what's nice about that is that closer connection is not tax treaty dependent. So we don't have a tax treaty with every country in the world.
Right.
Okay, and so my Singaporeans are, you know, there's no tax treaty to rely upon. Okay, and so using closer connection gets you out. They just can't be in the United States for at least 183 days during the year.
And is that an election you can claim, or you can request consideration of there being a closer connection, or is it, yeah, or?
Yeah, it's right. You can opt out. I mean, it's an opt out. And so you could just say, I thought, right, you're thinking about in terms of what happens if somebody wants to actually become resident here and sort of come in. Yeah, they can intentionally trip the wire. But if they decide they don't want to be tax resident, usually most of the time, Carolyn, my clients are like, I don't want to be.
Right.
And so they're tripping the wire. They don't want to trip the wire and they want to get out of it. And so for close, I think we're claiming closer connection. And what's nice about that is closer connection, you're statutorily completely out here, and one would need to do, there is a filing involved. You would have to file something called a form 8840 here, you know, either with a tax return or by itself to, you know, timely filed 8840. That's the form, that's the closer connection exception. And really, I don't see, I mean, look, my disclosures are pretty verbose, and I'm a disclosure type person here. I've never seen an 8840 rejected. It's not like you apply and it gets kicked back and it's rejected. It's just accepted. You have to go through that. And if for that, I think the IRS is just you're relying upon the basically the credibility of the profession. You know, that no one's going around filing, you know, fake 8840s. If they are, they're going to get prosecuted. And so there, it's just a question of following those forms. But that's the out.
Okay. Now, in terms of just coming back to the simple test, the 183, the dummy test, there have got to be exceptions to that as well, right? I mean, so first of all, does the closer connection exception apply in the basic test? No.
See, that's why I say simple and complex, because the complex one, you have the 183
days, you're done. But
183 days, you're done. But unless there's a tax treaty that will get you out.
But I'm thinking, what about the students though? The actual students.
So that goes to what goes into the day count. So a couple of things about the day count here. And the example I give to clients is that if you arrive at JFK and you exit Immigration and Customs at 11:59 p.m. on Wednesday, October the 20th, that Wednesday, October the 20th counts as a whole day. There are no fractional days. So you're talking about, there are certain categories of visa holders, students, teachers, for example, where you don't actually count days. There are exceptions to the day count rules. Okay. And so you're thinking about the student visa exception here, the 5-year exception. It's really a lifetime exception. And so a student can, under F status, can claim up to up to all of a portion of 5 years. Just don't count my days. Now that's another filing. That's a filing called an 8843
Okay.
that the student has to file as well.
I think this
What's
is important. Yeah.
It's
go ahead.
very important. It's extremely important because I have a number of students who are clients who go from F to EB5, here, due to family wealth planning. And so for them, we're pivoting, tax residency there and being able to make sure that they're non-resident. And of course, planning things. Here's a key nugget for those who are out there who are listening or talking, who are practicing EB5, and that is that under this exception, the student visa exception, it doesn't matter what the student does for immigration purposes, as long as they're in F status and in good standing, okay, for those 5 years, okay? As long as they're good, they're fine. After 5 years, they can still claim the exception, don't count my days, if they do not take steps to acquire lawful permanent residence, okay? So you see where I'm going with this, okay? And that is that if there's a family plan to, if there's a plan for the student to obtain EB5 status, or the filing EB5 petition, it's better done on the front end while it's not going to affect their day count exemption. Okay, and so there's a number of them there.
Well, by front end, you mean before they acquire F1, or what do you mean by on?
No. I mean before the 5 years are up, while they're here as a student. So while they're here and their days are excluded, they can petition away.
But wouldn't they trip it up once they?
Yep.
Okay.
Well, they will once they acquire. But they lose the day exception if they're in year 6, okay, and they petition.
So they'll get at least they'll get a little time.
They'll get time.
Within the 5-year window if they start early.
That's right. That's right. And so what's interesting there is I have a number of wonderful friends in government. I started in government. But whoever designed the form 8843, which is the day count exception form for the IRS, at the bottom of the first page, I can visualize it there. It makes it sound like you lose the exception even in year 1 or 2 if you take affirmative steps, and that's not the statute, that's not the regs. And so we have to explain to clients why it's there. And yeah,
this is why we need you in our world.
It's a booby trap. Here we go. Our Big Bang Theory moment here. It's a trap. Abel Akbar, if you're a Star Wars fan, right? It's a trap. It's a trap. From Revenge of the, excuse me, that movie was originally supposed to be called Revenge of the Jedi, from Return of the Jedi. I have a colleague of mine who's in PR who has a poster from 1983
that calls Revenge of the Jedi.
It says Revenge of the Jedi. Yeah.
Well, they brought back the Revenge of the Sith.
Right. So
it's not lost in the Star Wars universe. I love where this conversation has been. We've been in Star Wars. We've been in Star Trek. We tossed a little tax in there. This is fabulous. Great. Okay. So that's substantial presence, so we kind of touched on this. Most of our clients are looking to stay away from substantial presence. Some clients are seeking to establish it. So, I imagine the rule is what it is and you apply it how you apply it. Are there some meaningful differences in the way you approach a client who's trying to establish tax residency as opposed to those who are trying to stay away from it?
Well, I think there's more emphasis on coordinated advice, because if they're looking to establish, they're fleeing a jurisdiction. They're leaving a jurisdiction. They're leaving tax residency in another jurisdiction. Canada, the UK, for example, is another one I deal heavily in, and so that has the key of coordinated advice here. And I think one thing that's there, regardless, sometimes substantial presence is just going to be inevitable because it's just the circumstances of the nature of their life, of the client's life. But when an individual is looking to establish it, they're just focused on that. Often what we engage in is what's something called a reset. And what I mean by that is when one becomes tax resident in the United States. And to be clear, tax resident also, another term is resident alien. Here, I don't like to use the term, but that's the U.S. term that's in the code, the Internal Revenue Code and the regs here. The international tax law term is tax resident. And so, but when one is tax resident in the United States or any other country, for the most part, they're taxable on their worldwide income. And so when someone, a common pitfall or common mistake is someone thinks, oh, when I come to the United States, now I know I'm subject to tax on my worldwide income, but I get a reset of the cost of all my assets. For example, if someone buys an asset, they mined Bitcoin back in 2009, okay, and they bring it into the United States, right? And they say, oh, but it was worth, it's worth $100,000 when I moved. You know what's worth when you sell it in the United States? It's the cost basis, zero. Okay. And so where I'm driving at here is what we often do is we often perform what's called a reset here. And that is that we might go ahead and sell assets, we'll trigger gains, recalibrate things for US tax purposes here to say, okay, when you're entering in, then you're sort of popping in. And so the US is only going to get the cut of when that happens. Now that's important. That's sometimes important just generally. It's always important with a country like Canada that has a departure tax, an exit tax like we do. And so there are these countries, Japan has one too. And so there are these countries that impose these exit taxes, and the US has had one since 2008. Is that these are deemed sales taxes. So they're taxing on a fake transaction, a pretend transaction, like you're selling things before you leave the tax system. The problem with that is having recognition by the new country of receiving the tax credit. There's this idea that people say, oh, well, I don't want to be double taxed. And the that general rule, it just sounds awful. Sometimes it's triple taxed, right. I don't want to be double taxed, triple taxed. The standard is, right, that under international law, the international law standard is that there's going to be a country of the two countries, they'll be assigned primary taxing jurisdiction, okay, based upon what it is. One country is going to take the lead, they're going to tax it. And then the other country may tax it as well, but they're going to be responsible for the relief, usually in the form of a credit, okay? If that second country's tax rate system is high, it taxes higher, that you'll pay tax on the delta, okay? The client pays tax on the difference, okay? If it's lower, there's nothing due, okay? I had a client who's a lawful permanent resident who was looking to move back to move back to, but wanted to go back to Italy for a few years. This is Italian. And so I told him, and so there's a special Italian regime that's just in place now. It's going to give me huge relief. And I said, oh, that's great. I said, but you're still a lawful permanent resident of the United States. And unless you want to, if you're looking to maintain your status, you're pretty much practically have to file 1040s. You're just going to still pay the delta back to the United States. Well, I think I'll abandon. I said, I think that might not be a bad idea. Yeah. And so yeah. And so that's kind of important to keep in mind in terms of a principle here that happens. Circling back to that point about these deemed taxes, well, they're fake taxes. And so there's no real transaction that's happened. Right. And so you've got this floating foreign tax credit that may not be applied until 10 years down the road until the asset's actually sold. It's kind of a
springing thing. That's the danger.
Yeah, it's just not worth it's not worth the fight. And so, and to give you a little bit of Cartwright family history here, I've gotten along very well with a spirited debate family by looking around thinking, is this really worth the fight? Should I get involved? Nah, not worth the fight. And so I stayed in good stead with my elders when I was growing up, saying, don't argue that one, it's not worth the fight.
Very prudent of you. I was always the one to rush headlong into a fight. So yeah, I'm mellowing. I am getting wiser, which is good. All right. Well, Clayton, I definitely want to leave room for questions because that's the benefit of joining us live, gang. So I do want to close with, how do you work with prospective clients? So I am talking to a client or a prospective client, and they're asking these awesome questions that I can't answer. and I want them to talk to you. How do we do this? How do we work together? How do you work with prospective clients?
Sure. And so my practice, and I've had my practice now for, gosh, 19 years now. I'm referral only. And so anybody who wants to meet and engage with me, not engage in the engagement letter sense, but just to, to speak with me and develop a professional relationship, I'm open to here. But then I take clients by referral only with professionals, and what I loosely define as my network. I do not, if someone just cold calls me, I don't know who they are, I tend to not do anything there. I might redirect them somewhere else here. But as the famous tax lawyer, Marty Ginsburg, I'm paraphrasing him, I was blessed to have him for 2 semesters of tax.
Husband of Ruth Bader Ginsburg,
at Georgetown. Ruth Bader Ginsburg's husband, Justin Ginsburg's husband, who was famous in his own right as a tax lawyer. He always would say something along the lines of, I'll talk to you all day long. If you want my advice, you'll have to hire me, sign my engagement letter, pay my retainer, something along that. And so my point is that for me, it's clear that the engagement relationship needs to be firmly established before advice is rendered. And I think that needs to be made clear, not just for the protection of the lawyer, but also for the protection of the client. So the client often doesn't understand, well, I talked to this lawyer and they gave me advice. Well, lawyer really didn't give them advice. He just talked to you here and there was nothing there. There's just a pre-engagement discussion. And so there's nothing there for reliance purposes.
Right.
And so I have pretty clear lines. They should email me.
Yeah.
And so my email address is ccartwright@lawcart.com. First initial, last name @lawcart.com. I stumbled into that 7-character domain name back in 2002, and I will not let it go because cartwrightlaw.com and lawcartwright.com were taken. And then I spoke to my my tech advisor at the time, and they said, well, you can try something else. You can try .org. So what about Lawcart or Cart Law or something like that? And so, Lawcart's a good one. So snag it. And so, and so they can email me directly is the point. They can email me directly here. We are email only until we establish the relationship. And then we will schedule initial consultation there, much like this one on Zoom. Here, if the client prefers, or we can go old school audio conference. It's rare that I do anything in person in terms of initial consultation.
Yeah.
Nobody does them anymore in person. At least I don't.
These are behind us. Awesome. And presumably you're consulting with international clients in different parts of the world and all of that.
Yeah.
Yeah, of course. Okay. So should we take some questions, Clayton?
Sure. Let's do it.
Questions from the floor. Okay. So one question is, Clayton, can you advise on estate planning issues as well as immigration traps for foreign nationals in the middle of these issues? So what if they're kind of
the estate planning question here? And so the answer is jack of all trades, master of none. The answer to that is I don't advise. I mean, I will advise on what we call citing assets here. What, for somebody who is not resident in the United States for estate and gift tax purposes, I can give an opinion on that. And if they're not, then we can show what's U.S. subject to U.S. tax and what's not. But in terms of drafting wills and trust, no. The reason for that is that I have some wonderful estate planning professionals with whom I've worked with before. I worked with a great one back in the 90s. And he's a master, jack of all trades, master of none. I just don't have a proclivity for it. I don't care for it here. And so, it's my referral. I would refer to the network here. Yeah.
Okay. No question. Just hello to Mr. Cartwright from his former legal assistant from Morgan.
Oh my gosh. Yeah, Morgan. So Morgan is my, you wanted to do a Star Wars. You mentioned that your love of Star Wars. Well, I always called. Yeah, she was my Padawan. So she was my Padawan. Morgan actually has an LLM in tax from Georgetown. So she's sort of. I don't want to say everyone has their own path here. So I I was as blessed to have her in my life as hopefully I've been in
She
hers.
she did not slip it to the dark side. She stayed within your tax profession, well within. Nice.
Yeah.
Well, hello, Morgan, welcome. So here's an example of a question that might be too specific. I'm an EB-5 applicant. Once I become an LPR, I plan to stay in India first for a bit before migrating to the United States. While in India, when I file tax in the United States on income earned in India, do I have to pay both federal and state tax or only federal tax? Will the state tax be applicable only on income earned in the state? Yeah, I mean, is there any part of that is like a general principle that you can tease out? It feels
Sure.
like this is might be too specific.
And I can give some
Yeah,
some
okay.
general, some cocktail party pointers here.
Great.
Like this. Yeah, this is a mid-afternoon cocktail party.
There you
And
go.
so,
Never early.
right.
Poorly.
Yeah. So from here, it was a question that they were approved, but they hadn't triggered yet.
Not
Because-
sure. I mean, he's still in India. He plans to stay in India before immigrating.
Okay.
I don't know where he is in the immigration.
Let's just
process.
assume we will go past what assume means, and we'll assume
Yeah.
that the person's already acquired status and they've already got a residency date on their green card.
Okay.
So that goes to the issue of green card of lawful permanent residence maintenance while abroad. And so here, it's expensive to maintain lawful permanent resident status abroad. And what I mean by that is there are things, practical things, even if they're allowed for tax reasons, there are practical things that one should not do. One should definitely file a 1040, Form 1040, which is the standard US tax return claiming taxation on worldwide income, period.
Mhm.
Okay. If you don't do that, then there's 25-year-old guidance from the immigration authorities in the United States, from Legacy INS, that states that that's a presumed abandonment of the status. You have to file 1040s. Now, the question about state is an interesting one. So I often tell clients here when they're talking about acquiring it, I said, well, what do you plan to do? Where do you plan to live?
Mhm.
There's a reason why there are lots of individuals who are green card holders, colloquial term for lawful permanent resident, who have their homes in Florida.
Mhm.
Because there's no state income tax in Florida. And so you have to you should, for purposes of maintenance status, this is more along the lines of wisdom, develop a connection to at least one state to be resident in the state. So the answer to that is yes. Presumably, Carolyn, you would advise them about having some type of physical dwelling or having a home, developing ties. Developing ties there. And I always say the best tie there is having either a home that's yours that you're not renting out now, but it's yours that you have access to, or renting an apartment or something like that, or developing those ties there as you're going along. The LPR status is not a metro ticket or a subway ticket in and out of the United States. You have to do things to maintain the status. There are other things to go through as well. But this is also the driver of why individuals who are in the United States, who are lawful permanent residents, who are looking to go abroad, they might be eligible to naturalize.
Mhm.
And so if their long-term perspective connections are still with the United States, it actually may behoove them to go ahead and naturalize, because all these things I'm talking about now, if you're a citizen abroad, you don't have to file a state tax return if you don't have a nexus to a state. You don't have to maintain citizenship. And there's things about what we call the foreign exclusion, claim those. Whereas if you're an LPR abroad and you claim them, you might get yourself in trouble with maintenance of your status. And so it's actually liberating. And so it's important to mention that.
That actually addresses a question. Are there big picture differences and tax implications between a long-term permanent resident green card holder and a US citizen? And you just
but there's a loaded question there, because I mean the long term, if they're saying it there, if it's what I think it is, that there's I don't mean there was an intent that was there, but long-term lawful permanent resident also can mean long-term resident, which is an exit tax term. Okay, and so that's the other issue too. And so there usually there are really the big issue difference between the two, between citizenship, just the main one here, and it's not even really an international tax principle, is the marital deduction for gift tax purposes. There, I mean, it's you get an unlimited deduction if your spouse is a U.S. citizen. Otherwise, you have to set up a qualified domestic trust here in order to do that at death. And so that's really the real big difference. I don't really, when I have that question here about whether or not, or a consult on citizenship versus lawful permanent resident status from a tax perspective, is all sort of guided towards all the cost of maintaining your lawful permanent resident status and how it's a creature of statute as opposed to a constitutional right that citizenship is.
Right. Okay, well, hopefully that was enough to go on. Feel free to ask follow-up questions on that. What is the best time to start seeking tax advice for a person who is moving to the States? Should he seek advice after the I-526 approval, or after the visa application, or after moving to the United States? I will say that, and then I want Clayton to address this, because this was our very first question. It also depends on whether you're from a country that's experiencing a visa backlog or not. Because if you're from China or Vietnam and you're looking at a number of years before you can land, that might factor in what Clayton has to say, versus someone from a non-backlogged country who might land within about 3 years from filing the petition. Okay, Clayton, you go.
Sure. I mean, it sort of harkens back to what we discussed at the outset, and that is whether or not there's already U.S. exposure.
Right.
I mean, many times when I'm doing residency planning, I'm giving advice on residency planning, and I'm looking and I see.
So if somebody was on an H-1B before filing an EB-5 petition.
That's the gentle one. The one that I'm talking about is individuals coming over on ESTA, okay, and having U.S. source income, even though they were not working, but they were operating at the behest of a company under ESTA or a B1, okay, but they were let's just assume that they were within the confines or operating within the confines of ESTA or their visa or the B1.
Now,
but they have U.S. source income.
This is interesting because they can't work, so it won't be earned income while they do ESTA or B1. But you did mention other income categories, including passive.
No. This is the big disconnect between tax and immigration. So, from a U.S. tax perspective, work is really not a term of art. And so the question is compensation for personal services rendered inside the United States. And so if a company sends someone over on a B1, for example, here on a B1, and there's no treaty exception, the statutory thresholds are so low, they're from the 60s. Okay, so if there's no treaty exception here and no treaty exemption granted, the person could have a filing requirement, for these prior years. Okay,
but the earned income won't be sourced from a U.S. employer. So what are we talking about here?
It actually, for tax purposes, sourcing of income is based upon where the services are performed, not from where they are paid.
So
yes.
B1 or ESTA could be here at a company at an employer's behest, an employer abroad, and not receive a penny from any U.S. source, continue to be compensated by the foreign employer, and have exposure, U.S. tax.
Yes, absolutely. Yes. And so when I'm doing a residency consultation, for example, we always do a compliance check. I always say here that good tax planning, if there's any nugget from the audience, good tax planning is built on compliance. Okay. I mean, I used to be an audit. So the first 3 years of my professional life, I was an audit. I'm not auditing my clients, but I am doing a compliance check here and seeing what's happening here, because there's no adequate planning unless the foundation is solid. Okay. Here. And so we do a check. And so there could be back tax returns that have to be filed, non-resident ones.
Let's answer this very practical question. It's important. What's the best time to start seeking the tax advice for a person who is moving to the United States? Let's assume that it's an EB-5 investor. And let's assume that this person has not yet filed the 526 petition.
Yeah, I think it has to be done at the outset. I mean, here, the nice thing about US tax law, at least on the individual side. Now, we might be going through the reconciliation bill, yet another change on the corporate side, but on the individual side, knock on fake wood, that the law is the statute's pretty much been firm since the mid-80s. Okay, now we've had some enforcement mechanisms that have come in, particularly the Foreign Account Tax Compliance Act from 2010, but the actual substantive law has been pretty solid. And so when they're starting that process, they need to at least start to take soundings from a tax advisor, someone like myself here, to sort of say, okay, what is it going to take for me and what's the plan? Because that's going to go up hand in, it's this coordination. It's going to sort of start beginning that's there, even if they're starting to look at it. If they're seriously looking at it, they need to look at this side as well here and at least get a rough idea of what they need to do. On inbound planning, I always take a balance sheet with my accounting colleagues. My accountants will take a balance sheet here and they'll build the balance sheet up to the point of tax residency, because we want to know what should the client keep from a tax perspective, what should they dump here. And sometimes there's things that we say from a tax efficiency standpoint, you should sell it. And they say it's worth too much to me. I said, well, now, eyes wide open. That's a form of peanuts. Okay. Yeah. Right. So it's important that they start initially, at least generally.
Yeah. I hear that. Okay. So here's a question. Any tax advantage for an alien, not a tax resident, setting a trust in the United States? Is that a trust and estates question, or is that something you can address?
Yeah, and that's something I really would not touch here, because the question is, I will say this, we talked about substantial presence. This is a good opportunity to mention this. Substantial presence is a issue of income tax. Okay, when you're talking about estate and gift tax, transfer tax in the United States, citizens, regardless of where they are, they're considered resident for estate and gift tax purposes.
Yeah.
Non-citizens it's based upon domicile. Okay. So substantial presence doesn't have any, it's not directly, there's no direct connection. Now, the more time you spend in the United States, the more you're probably gonna be domiciled here.
Right.
If you're a lawful permanent resident, you're deemed to be income tax resident in the United States. Okay. But it's not the sole driver to gift and estate tax residency. So that's a term that one should be very careful to use here, because there's two different meanings in the United States.
Got it. From the legal practice, so this is about coordination. This is a coordination question. From the legal practitioner's point of view, how do you coordinate with tax professionals? Examples, please, with a real case. For example, tax professional overseas, tax professional in the United States, immigration attorney and estate planning professionals you're now mentioning. So she's asking about how does this happen?
How does the work out?
Yeah.
Sure. So I often describe sort of the tax advisory function as a ship. The tax lawyers are kind of on the bridge, they're in navigation, they're kind of defining where things are going. The accountants are in the engine room here. And so because they're getting the data from the client. Okay, they're getting the data from the client. As you and I have discussed before, often my accountants have more of a relationship with my clients because they're getting the day-to-day, the day-to-day data from the clients here. And so they're feeding that. So from the standpoint of model, that's how it works. Now, if there's other tax professionals who want to refer cases over, and this happens, but they're not experienced in international taxation. Okay, here. There's always a question of, what initially are they referring? In other words, if they want to refer a case over, we have to be very careful, because they might be referring a case where they messed up right here. And so you have to be careful about who your client is. And so making sure that, that's in place. And if there's no issue, no conflict that's there, the existing tax professional pretty much would be, if they have the relationship, with the end user, okay, here, presumably the end user is the client. If they have their relationship sort of remains the same in terms of preparing everything else. And then there's the overlay that comes through. I don't, for me, I always tell a client on a consult here that I don't just tell them to go out and find an accountant. Okay, here, I have accountants with whom I work. I don't pay referral fees. I don't charge referral fees here. I just place based upon competence and really based upon what the perceived fit with the accountant is going to be with my client.
That makes sense.
Okay.
So
Yeah.
I think also the part of the answer is it's going to be kind of case by case too, depending on who the client has the best relationship with, what the client's comfort level is, where the client is in terms of work with these various professionals, and also the other professionals involved. They'll have their standard operating procedure and preferences. So yeah, and I think this is where what you said about kind of keying into where the client is also comes into play.
Yeah.
One kind of technical and very specific question, but maybe we can tease out something. And we are at the top of the hour. So for those of you who are leaving us, thank you so much for joining us, and we'll see you soon. This technical question goes, I used to be a green card holder between 2007 and 2008 and then relinquished it. I used to live in Cincinnati, Ohio, and was a tax resident there. I'm now an EB-5 applicant and expect to get a green card in 1 to 2 years. Will my tax residency continue to be in Ohio, or can I establish residency in a different state where I plan to live, for example, Texas?
Yeah. Okay. So I always have the proviso that I'm not licensed to practice in Ohio here, so I can't speak specifically to Ohio law, but I mean, presumably when they said they relinquished it, presumably they went through, as you and I know, the formal process. They filed a form I-407, and they back in the good old days when you could file it at the consulate, right? The good old, I call them the good old days, as opposed to the mail process we have to do now. Yeah, I would say not at that point, just from a general general SALT. No one knew what SALT meant until there was tax reform, the reconciliation bill, and SALT is state and local tax, here, because you have that $10,000 cap that, that they want to eliminate on itemized deductions. But from a state and local tax perspective, generally, probably not here. I mean, and so, but the key point is to make sure that you're establishing, if you're obtaining lawful permanent resident status, a very key thing, a very wise thing to do is to pick up an established tax resident in a state here. And again, I mean, or to say it differently, let's say what's a bad idea. Okay, it's a bad idea to have a nominee address, like your friend take your mail, or have what we used to call the mailbox, et cetera. Now it's UPS, whatever it is, the UPS store. Okay, to have an address there, or just a P.O. box, or whatever it is. You've got to have something. Now, you don't have to be here all the time, but you've got to have something that's exclusively yours. It's a bad idea to spend $1 million on a house in the United States and then rent it out and don't have access to any of it. You've wasted your money, okay, unless you're just using it as a real estate investment. It's not going to help you maintain your lawful permanent resident status, okay? So those things are important. It takes a lot of it takes financial investment, it takes intent and emotional investment to maintain, because we're talking about domicile and permanent residence and state of mind and all that stuff. And so it's important to make sure that sort of falls, sort of comes hand in hand. And I think that's often missed here, because I think it's kind of like the EB-5 is like the end of the romantic comedy, or the end of the romantic movie. Okay, it's the wedding. Okay, I have some very good friends of mine. I've grown about this, but they watch like the Hallmark Channel. Okay, and so all those movies, they all end. My mother loves it, right? At the very end, there's always a wedding, right? Yeah. And the wedding, and it's over, right? And so getting the permanent resident seems to be the end. Okay, and they feel like that's the end of the process, but it's only the beginning. You have to maintain it. You have to put the work into it, and everything else, like a marriage. Here, and you're right, and so that's something that's often lost.
And certainly with EB-5, since there's a third filing at the end of 2 years, so it's definitely not all over. It's in some sense, an important sense, just the beginning. All right, one final question. A U.S. citizen purchases an overseas company share. Basically, it is true that no tax issues if the share of the target company is under 10%. U.S. citizen. Okay,
He's
so
talking about control foreign corp. The question goes to what's called a control foreign corporation and what's called a form 5471 here, which is a specific tax filing here. They want to know whether or not they're a U.S. shareholder for certain tax provisions to prevent the offshoring of income that's only claimed as income upon remittance back to the United States. I know that's a mouthful, but that's what they're. So the gods above all declare with great certainty, it depends. And so it depends. I mean, it depends whether or not here, what the other shareholders are. Okay. And so probably the person's free and clear, but I'm going to tell you something here when it comes to this, because they're talking about, it doesn't matter if I'm under 10%, what's the company? Because, their concern is, well, gee, you got this 5471 filing, maybe it's controlled foreign corporation, which is another version of tax hell, but it's not, if we're looking at Dante and, the levels of hell here, being a controlled foreign corporation is not as bad as being a passive foreign investment company. So the person who asked the question, you might have just bought into a PFIT, a passive foreign investment company. Okay. And so you need to look at that and see if that's the case. And I'm not trying to scare people off of foreign investments. What I am saying is that, the United States writes its own written its own tax code. Of course, the rules are going to be skewed towards U.S. investments. Of course they are. Okay. And so that means that investments in overseas companies, they're moving it out of the U.S. economy, not a great idea from a tax policy perspective, but two, also an opportunity for evasion. Mm-hmm. Okay. And so, so there's a concern there as well, because if you don't have a controlled foreign corporation, you may have a passive foreign investment company. So, and to be clear, you may be in the free and clear, but don't just pass off and say, I'm okay, it's under 10%.
Yeah.
Nope. So I have work to be done.
Yep. Well, I think that is that's one of the key lessons and takeaways from today. We can't assume that we're in the clear and we're good without some real technical, competent tax advice in this area, especially for investors, especially for high net worth individuals and families. So, Clayton, you make tax fun. I can't think of a higher compliment than that. Thank you so much for joining us. And
thank you, Fred.
Yeah, we'll keep talking. Take care.
Thank you.
And thank you to our audience. Goodbye and see you soon.
Bye.